Welcome to the first in a series of seminars for VLN's 2021 Annual Housing Law Seminar. My name is Mariah Kruger, and I'm the Housing Program Manager and Resource Attorney at Volunteer Lawyers Network. We are so pleased to have you in attendance today. This year, instead of doing a day-long CLE for our annual Housing Law Seminar, we are breaking up our seminar over 5 Fridays during the noon hour in April. Sharing what is the schedule of all of the events that we'll be having this year for the annual Housing Law Seminar. Our goal for these trainings is to begin to build the foundation for providing legal services at the end of the eviction moratorium. Make no mistake about it, we are going to need you to volunteer your time at the end of the moratorium. Additionally, we need volunteers who will take phone vice shifts, eviction expungement cases, and housing court shifts at initial appearance hearings right now. You can find out information about all our volunteer needs on our website. In just 1 second, I'm going to stop sharing. Back. In addition, if you are interested in getting involved in our housing program, our website is a great place to start. Also, as soon as we begin to know more about what the end of the moratorium will look like, we will be contacting all our volunteers with more information about our needs at that time. Now, before I introduce our speakers, I have a few housekeeping items. First, we've requested CLE credit for the training portion of this event. We've got 1.5 standard CLE credits that are pending. The CLE code is 353128, and we'll put that into the chat box for you now. In order to request credit, we need to keep track of the names of those people who have attended. If your name is attached to your Zoom account, we have a record of your attendance. If your name is not attached to your Zoom account, please send a chat to the panelists only with your name. It will not be broadcast out to the entire group. If you are calling in, please email Kate, whose email address was on the confirmation, to let us know of your attendance. Second, if you have questions during the event, please post them in the Q&A. Mayor Fry will not be answering questions from his presentation, but our CLE presenters will. And third, while I'd not normally take a moment to point out the restrooms, you probably all know best where they are in your own individual space. Please also feel free to enjoy your lunches, play catch with your dog, collect your package from Amazon delivery, and assist any children who may be hanging around with their homework. We're still all remote and you're on mute, so let's enjoy this while it lasts. Now I'd like to introduce our speakers. First, it gives me the greatest pleasure to introduce our first speaker, Mayor Jacob Fry. Mayor Fry has been a supporter of VLN's housing work, both as an attorney at Faegre Benson, now Faegre Drinker Biddle, and by joining with VLN for the More Representation Minneapolis initiative in 2019. Through that initiative, Mayor Fry asked Minneapolis law firms to commit to doing full representation of eviction defense and repair work through VLN, and we set benchmarks for our performance. Through your commitment, we were able to meet our More Representation Minneapolis goals almost 3 months in advance. It also bears mentioning that while none of us expected the depth and difficulty of events that we have faced in 2020, our leaders, and in particular our leaders in the city of Minneapolis, have faced a special burden this year. In the absence of magic answers, which really don't exist, the real world answers we desire can never come fast enough. I wish to thank Mayor Fry and our elected leaders who continue to shine lights in the directions that they think we should go and push for progress that can never come fast enough. After Mayor Fry's kickoff, we will be hearing from Larry McDonough, the preeminent housing lawyer in Minnesota with an over 30-year legal aid career, having taught at all 3 Minnesota law schools and now serving as the senior Minnesota counsel for the Lawyers Committee for Civil Rights under the law. He will be presenting along with Rachel Sterling, the COVID-19 eviction response coordinator and housing attorney at Homeline. The title of their presentation is Eviction Actions in the Pandemic and Afterwards. I'm anxiously awaiting all that they have to say. So without further ado, I'll hand the virtual mic over to Mayor Fry.
Thank you so much, Mariah, and to everyone at the Volunteer Lawyers Network. It has been such an honor to work with you all. Yes, we have had a heavy and difficult year, but it's been I have such profound gratitude to those that are really stepping up to make a difference. And VLN has been there every step of the way. And so I'm so honored and happy to be part of this VLN event. It is absolutely essential work because I think we all believe to the core that housing is a right. And we can step up and use our skills to ensure that housing for our friends, for our neighbors, and when we can do that, it's an absolutely beautiful thing. And so I want to take a quick minute just to talk about what we have been able to achieve over the last couple of years. And it has been significant. And like Mariah said, there are no magic solutions. It requires people doing that work on the ground at Hennepin County District Court, in our shelters, in our affordable housing developments, to ensure that we can ultimately transition people from those that are experiencing homelessness into long-term and stable housing. So here's some of the work that's been happening. In 2019, VLN placed 141 full representative cases, which was a significant increase, by the way, over 2018. And in 2019, again, during the pandemic, VLN focused on full rep case placement and increased that number to 182 cases. Again, the goal when we started out was a 20% increase in representation, far surpassed that goal, and we're still moving. So thanks to your commitment, VLN volunteers are also present at every single eviction on the calendar in Hennepin and Ramsey, and frequently they also are at eviction cases in Anoka as well. I'll note that when we first started off this program, I wanted to call it the Sixth and a Half Amendments, noting that Sixth Amendment was, of course, the right to counsel in criminal proceedings. I would love to see a right to counsel in full scale as well for tenants that are facing evictions in some form, because we know that a tenant's ability to defend against an eviction goes dramatically up when you have some form of legal representation with you. And for those young attorneys that are looking for additional trial or in-court experience, this is an excellent way to get those practical lessons right up front and simultaneously help somebody that really deserves it. And so it's been in partnership with the local legal aid organization, with VLN volunteers and legal aid staff attorneys, that they are ensuring that no eviction case goes through court in Hennepin or Anoka or Ramsey counties during the moratorium without having at least the opportunity to speak with an attorney about this case. And I want to also take this moment to use a plug. If and when the moratorium is lifted, we are going to need to collectively step up even more. Times will be tough. We're going to need to make sure that our neighbors that are experiencing housing instability and homelessness, again, they are treated justly and fairly under the law. And we need to make sure that we've got the necessary revenue and subsidies that are going forward to make sure that people aren't getting evicted. Because if we don't, yes, we could be in for a tidal wave of difficulty. So here's just some specific examples of the impacts that you all have achieved in this past year, and they have been so substantial. First, on eviction defense. VLN worked to counsel a tenant in a multi-unit apartment building whose landlord was illegally terminating the tenancies of all of the residents, not just one, but all of the residents in the building. Referred the case to the AG's office, which resulted in the landlord's rescission of that decision to terminate all of the leases. So you protected an entire building full of tenants that were facing eviction at that moment. You successfully defended an eviction case at trial where the landlord was trying to terminate the tenant because she was demanding that the repairs be made in her dilapidated unit. And by the way, that happens all the time. Tenant tells the truth, says the premises are uninhabitable. I'm not going to pay my rent because of it. And the landlord tries to evict without ever making the necessary upgrades and upkeep that they're required to under the law. This tenant ended up being able to stay in their unit. And I know that you've also successfully defended a number of tenants where the landlord was proceeding incorrectly or failed to adequately justify the eviction under the eviction moratorium exceptions. Next, under repair and habitability, which undoubtedly can get very complex. There was a tenant that moved into the apartment where its apartment sites unseen due to COVID and discovered that there were major problems. A cat had totally soiled the place. There was mold in the apartment that the stove wasn't working. The stove and refrigerator were infected with cat hair and dander. Front door didn't work. And so the entire family was experiencing health problems due to the circumstances associated with the unit. And after a VLN volunteer sent a 14-day letter, the landlord made some repairs, but did not replace the carpet, the stove, or the lock. The VLN volunteer then went even further, brought a rent escrow action, getting the landlord to make all of the requested repairs and crediting the client $1,500 in rent abatement. That is a sign of success. An eviction expungement, which has been one of the preeminent forms of work over this last year. I know VLN worked with a client who was living in a shelter due to getting evicted and making sure that the cases were expunged, which helped the client to move out of the shelter and then into permanent housing. Getting your record expunged from eviction is so important because we know that it can serve as a black mark on your record in some cases indefinitely. And so making sure that these are expunged is of huge importance. I know there was another VLN case where you worked with a client who was living at the Powderhorn Park encampment to get an eviction case expunged, which then helped that client again proceed into permanent housing. And that should always be the goal. And that's something that VLN and legal aid understands to the core. The goal is not shelter. Shelter is a temporary step. The ultimate goal is stable and long-term housing with the necessary wraparound services to allow anyone to grab that next rung on the ladder to pull themselves out. So those are just a few of the fantastic results that you all have been able to achieve thanks to your commitment to this work. But we know that there is a whole lot more work to be done in the next several months. At the federal level, the eviction moratorium has been extended to June at least, and we don't know exactly when, but we do anticipate sometime after this legislative session that the eviction moratorium will be lifted at the state level. And as I mentioned previously, this will mean that there will be a whole lot of people that will need our help. And so I'll close by just imploring you all to be engaged with this work if you're able, and certainly ramp up the work to the extent you're able to as well. Thank you so much to VLN, to all the volunteers. This work, it makes an incredible difference for people who need it. Making sure that people have housing stability and they're not getting unjustly evicted from their units is so critical right now and is a foundational element to ensure that our entire city can succeed. Thank you for your work. I can't tell you how much I appreciate it. You've got a couple of great speakers in Rachel and Larry that are going to be jumping in just a second here, but I'm going to turn it back to Mariah, who again has been a hero throughout. Mariah, I cannot tell you how much we appreciate the partnership. And Peter Ebnett from my staff have been working constantly together, and it's benefiting a whole lot of people. Thank you so much.
Well, thank you, Mayor Fry, for your time today and your partnership and your kind words. We wish you all the best and look forward to where our partnership will bring us going forward. With that, we'll transition to the next portion of our event today, and we will welcome Larry McDonough and Rachel Sterling. Take it away.
Thank you, Mariah. We'll let Larry get his video up here. He's the one who's going to be sharing his screen today. So I'll introduce myself. I am Rachel Sterling. I am the COVID-19 Eviction Response Coordinator with Homeline. And I am been working with Larry in a couple of different things. So Larry now has his video on, so I'll turn it over.
All right, thanks. Thanks, Mayor Fry. Thanks, Mariah, and thanks, Rachel, for teaming up on this. And thanks to all you folks for showing up. Can't see all your faces, but I did look through the list and a lot of familiar names there, people that have been doing a lot of heavy lifting here for a long time. So thanks for coming. So what we're going to do today is update you on where evictions stand in the pandemic, some of the issues that can be raised in cases right now. There are some cases that are going through the system, not as many as before. So we'll talk a little bit about how to navigate those cases. We'll talk some about planning for when evictions open up and for some of the issues that arise there. Since some of you are maybe newer to this than others, we will cover relatively quickly some basic elements of eviction defense work. So I'm going to share my screen right now. And so here's our slideshow, and I've emailed the slideshow to Mariah so she can circulate it if needed. And I'm also going to show you where it is located on my website. So I'm going to go over to that for a moment. The website is called Housing Law in Minnesota. It's a kind of segment of a website that I teach from called Poverty Law. If you Google housing or poverty law and my name, you'll find this website pretty fast. If you ever get to the website homepage and you want to get past some of the classroom teaching aspects, if you just go down to housing law, that gets you to the Housing Law in Minnesota page. And as you can see, there are a number of resources up there, including my eviction defense manual, which is under manual here. And then the slideshow is under pandemic eviction and other housing laws and rules. And so I've got the executive order here, the present executive order. I've got some various slideshows that I've done for different audiences, so or that Rachel and I have done together. So one is pandemic eviction estimates. That'll be part of what we're going to discuss today. And then the section for lawyers down here has both the slideshow here, both in PowerPoint and PDF. And I'm happy to announce today that I've updated an eviction defense manual for issues that arise in the pandemic. And it's in various formats here. It's in PDF or HTML. I'm just going to pull up the HTML for a moment. And so everything is linked in here. So for instance, let's say the table of contents is linked. So let's say you're looking through some cases down here. Related to the length of a termination notice. And I have various hyperlinks in here. So if you need to go back and look at the executive order, you can do that. The different cases that have come out that I've got in my library now, I also have hyperlinked as well. So this case here, the Rogenkamp case, is one that in part talks about an LSC cannot have a family member for the purposes of trying to evict a tenant to move a family member in. And so if you wanted to look at that decision, you just click on it, it pulls up the decision. So if you need to use any of these decisions when you are taking cases and you're in hearings in front of judges or referees, you'll be able to then take these, download them, and have them be part of your submissions as well. So again, that's just hot off the press today. And we'll be talking about some of the decisions that are discussed in there, but this is a more comprehensive version of what we're going to discuss today. So I'm going to go back to the slideshow now. This is not a brand new slideshow. I've been messing around with this basically for almost a year. And then Rachel joined me in the fall, and we've been presenting, as you can see, to a lot of courts, to law enforcement, and to attorneys and law students as well. And I'd have to say the response in law enforcement and from the judiciary around the state has been really positive. I feel like they're really taking this executive order seriously and really digging into the operative words about when evictions are available and when they aren't. And again, we've got contact information for both Rachel and myself. Rachel's bio is legit. Mine's a pack of lies, but you can always read it for comic relief if you'd like. Okay, so we're going to talk about a few resources that are out there, and then we're going to get right into talking about the various eviction orders and laws. We'll talk a little bit about health impacts, about why we believe these laws and orders have actually been helpful, not only for tenants, for the general population in terms of health. Then we'll go into a little bit of eviction basics and then jump into eviction actions in the pandemic. We'll talk a little bit about planning that's going on right now for when evictions open up. And since non-payment of rent cases, a little foreshadowing here, are cases that aren't being heard right now, we're going to talk about how to litigate those when things open up and a little bit of help and the like. So On resources here, I've already talked about my website, and this is actually an activated link to that, and this is an activated link to the pandemic page. Homeline also has, where Rachel works, has a lot of great resources on their website as well. Probably a lot of you have worked with Pro Justice. If you haven't, you need to get signed up. There are a lot of great materials there, not just in housing, but in any type of area in which you'd be doing pro bono work. And Law Help is a really good website for information, both for clients, fairly easy to read, small snapshots of the law, but also good for attorneys that are needing to get a little bit up to speed in areas they don't know. So keep all those in mind. Okay, we're going to move on and talk about the executive order. I'm going to hand it over to Rachel for that.
Thanks, Larry. All right, so just to start off real quick, Executive Order 2079 is what's called the eviction moratorium that's in place. There's been some sort of stays on evictions or limits on evictions since March of 2020. And it's gone through several iterations, and the current one, again, 2079, has been in effect since August of 2020. Basically what it does is it's protecting residents from being evicted by landlords. It also actually protects post-mortgage foreclosures, evictions, and there are some exceptions that we'll get to in a minute. I also want to point out that calling it an eviction moratorium is actually a little bit of a misnomer, because it also protects residential tenants from having their leases terminated or not renewed. So in this case, it means that they can't be evicted, but they also just can't be kicked out. A landlord has to continue to honor the lease that they had. So this is going to be remaining in effect as long as there's a peacetime emergency. So the governor renews that on a 30-day basis. The current one is going through April 14th, and it will need to be renewed at that point. And then that will need to be approved by the legislature. So it is something that, so long as things are not drastically improving, it's likely that the governor is going to continue to renew that, and it's likely that the legislature will continue to approve it for the foreseeable future. This is where we'll get into the exceptions that I talked about a minute ago. Paragraph 2 of the order gives the exceptions to what a landlord can evict for still under this moratorium. So if the tenant is seriously endangering the safety of other residents, if they are allowing illegal activity under Minnesota statute 504B.171. So this is a statute that's been in the books for quite some time, and it in general calls out controlled substances, allowing prostitution or unlawful possession of stolen goods or firearms on the property. But it also does cover through some linkages to 504B.206, which covers like domestic abuse, criminal sexual conduct, and harassment. And I point this out because a lot of there's been some confusion over what is actually covered under this particular exception. And so we've been hearing folks say, oh, well, I haven't been able to evict but my tenant is being harassing. And so that's something that I wanted to make sure that it was understood, like there are safety things that can be done in these situations. The next one I'll kind of just gloss over a little bit. We call it the family exception, and that will be the whole next slide. And finally, the seriously endangering the safety of others and significantly damaging property are also valid reasons to evict someone, as long as that is a material violation of the lease. So material violation isn't necessarily defined well. It does have some precedential definitions that the courts have used. Basically, as for any contract, basically if the violation would nullify the contract, then it would be considered material. And just to really hammer it home, non-payment of rent is not a valid excuse to evict someone right now. We're going to continuously say that throughout this whole thing, but it is, if a tenant is behind on their rent, they cannot be evicted, their lease cannot not be renewed, and their lease can't be terminated because of that. So as promised, I said I would get into the family exception a little bit more. So paragraph 4 allows a residential landlord to either terminate or not renew a lease if it's coming to its natural end. If they need to move a family member onto this particular unit, and that family member is going to be able to move in 7 days after the tenant has vacated the unit. So there's a couple of different hurdles that need to be achieved there. Now, the executive order doesn't define what need is, and they also don't define who a family member is. So there's some vagueness there. And as far as the time frame, that's something that does enter into the consideration of whether this is being violated or not. We've seen a lot of landlords who are trying to work around, use this exception when particularly when they're selling a property. They'll say, oh, we want to evict somebody. We're going to use the family exception to not renew the lease. But really what they're doing is putting the house on the market and selling it. And that is clearly a violation of it. Also, because even if they say sold it to a family member who then we needed to move in, they would need to do that within 7 days of the vacation of the tenant. And that's very unlikely that's actually happening. So that is the family exception. Paragraph 5 really has more to do with law enforcement and the judiciary about writ of recovery. So there's only a couple of reasons why one can be still executed at this point. So clearly, if the writ was made before the executive order was put into place, if they were under a valid exception that we just talked about, then they can be fulfilled. Otherwise, paragraph, excuse me. The thing to note, though, about this one is that the executive order doesn't limit this restriction on the writs of recovery to just residential tenants and residential tenancies. It also covers writs for commercial tenancies and writs for those post-mortgage foreclosures and contract for deed cancellations. So this is actually a much broader paragraph than a lot of the other parts of the executive order are. And so that's something to keep in mind as well if you are also taking on some of those other types of cases, that those writs of recoveries do have to fall within those exceptions in order to be executed.
And this is one area where I think, because most of the executive order deals with residential tenancies, that it's easy to overlook this section. And I wouldn't be surprised if there have been some evictions involving commercial tenancies that have proceeded. The way we read the executive order is that the commercial landlord could file the eviction, could terminate the lease and file the eviction case. But when they get to the end of the case, if they win and get a writ of recovery, the sheriff is actually precluded from enforcing it. I'm not sure if that was an oversight or not, but that's the plain language of this section of the executive order.
Absolutely. So moving on, we'll go to the notice requirements. This is actually another place where this is where a lot of landlords fall down when they do file an eviction action for one of those exceptions. So this executive order adds in a new hurdle as well, is that they have to give a written notice at least 7 days prior to them filing the eviction to the tenant that they're going to be filing the eviction action if they either don't fix things up or that sort of thing. So it has to be at least 7 days. It has to be written. If there is some sort of notice period in the lease that would pertain to this, then that would be the one to follow as well instead of the 7 days. But frankly, a lot of leases don't have any sort of eviction notices written into them. So in general, it's going to be a 7-day notice, and judges are looking for these. So even if someone had a valid reason to evict, there was illegal drugs on the property or something like that, if they didn't file this, show that they gave this written notice to the tenant, then the cases are in general going to be dismissed. Finally, just a couple of more housekeeping bits. The Attorney General is the one who is in charge of enforcing this executive order. So if someone is being told that they have to vacate in violation of the order, then they can be reported to the Attorney General, who can charge them with a misdemeanor and be punished with a fine up to $1,000 and potential jail time as well. And the Attorney General has enforced that. They have brought charges up against people for this. Most of those cases have been settled. I believe there's at least one that's kind of out there right now pending for a landlord who was trying to wrongfully use the family exception to sell a home. There may be others that I'm not aware of right now, but so this does have some teeth, and at the very least, the Attorney General is very actively aware of these situations and will send out letters to the landlords telling them that they are in violation of the executive orders. Should be noted that the executive order doesn't apply to properties on federal tribal trust lands, and that these are not creating, this executive order isn't creating a new grounds for an eviction. Even the one that's the family exception, while that might be new terminology, the actual eviction process for that is going to be just a standard holdover eviction, which Larry will touch on briefly later on. But basically, if the tenant stays over the term of the lease, then they can be evicted for holding over. And it doesn't restrict, if there's some sort of local requirements on quarantining or isolation, then obviously that needs to take precedence. And there was some debate earlier on whether this was a constitutional executive order, this moratorium. And so the Heights case, the judge looked into it and said very, very late last year that yes, this is constitutional. It doesn't violate anyone's due process. And so I haven't heard if there's been any rumblings after that, basically, but the judge was pretty firm that nope, this is a constitutional executive order and that it can stand as it is. So
Okay,
pass
thanks,
it over
Rachel.
to, yep.
Okay, I'm going to talk a little bit about the CARES Act. Some of you might have heard about that. It might seem like old news because this has been a weird year. So back a little more than a year ago, Congress passed the CARES Act. You might have heard of that because it's created an eviction moratorium nationally for a few months until the end of July. It also was the source of the first round of financial stimulus and unemployment expansion. Okay, so that law has been a lot of the aspects of that law have been out of effect for quite a while. But one provision is still in effect because it had no expiration date. And so a landlord of a covered property, and we'll talk about that in a moment, has to give a 30-day notice before they can file an eviction case. And that it's not limited to non-payment of rent, has no expiration date on it. And so then we got to know what's a covered property. Well, the short answer is it's federally subsidized housing and federally backed mortgages that are rental properties. And there's a fairly long list of subsidized properties. They're not all listed in the CARES Act, but they're essentially kind of listed by reference by the citation to the Violence Against Women Act, which applies in all these different types of housing programs. So essentially the whole alphabet soup of HUD and agricultural subsidized housing and public housing properties are covered properties. There's a way to figure out if you do have a covered property. So I've got a preservation database link here. A lot of times tenants know if they're in public housing or they have a Section 8 voucher or something like that. So usually this isn't going to be that hard to figure out. What's a little more challenging is figuring out federally backed mortgages. So a landlord who has a federally backed mortgage is a covered property and would have to give this 30-day notice. If their mortgage isn't federally backed, they wouldn't have to give this 30-day notice. So then how do you figure that out? Most people don't know. I'm here in my house. I don't know. I'd have to go look at my documents and see if my current kind of refinanced mortgage has a federal backing or not. Since I'm not a landlord, I'm not inclined to figure that out. So there are ways to figure that out. A lot of landlords don't know. If you're doing tenant advocacy, if I had an eviction case right now, I would want to figure out if it's a covered property or not, because then in addition to the other types of notices we'll talk about, so like as Rachel was talking about, you have to give the notice of intention to file the eviction case. Well, this would be a termination notice saying, but not that I'm terminating your case that I'm terminating your lease and I'm giving you a 30-day notice before giving the notice of intention to file the case. So it's important to look that up and isolate whether you have a covered property or not. So I'm going to hand it back over to Rachel, and she's going to talk about yet another player in the eviction suspension world.
Okay, thanks, Larry. I'm actually going to answer a quick, there's a Q&A question about when the legislature needed to start approving the extension of the peacetime emergency. And that was basically back in May, I think, last year. So the governor was only allowed March. Okay. The governor was allowed to do it kind of on his own for a little bit of time. And then after, I think it was like 3 months or something like that, he had to start getting approval from the legislature in order to do that. So that's why there was basically a once a month special session all through the end of last year, was because they had to reconvene to approve the peacetime emergency. And so that's why I said the legislature has to approve it at this point. Okay, so moving back, the CDC eviction suspension order. So this is the federal suspension order on evictions, and it doesn't really apply here in Minnesota, but we're going to go over it a little bit because it does have some potential implications for Minnesota. So it's good to have an idea of what it is going forward. So basically, this has been something that has been in effect since last year. It was originally set to expire at the end of last year. It's currently set to expire at the end of June. We just got that extension, I think it was earlier or late last week. So now it's set to go through June. There is talk about that Congress would extend it through the end of September of this year. That's going to be really up to the Biden administration. We just don't know at this point. But it is there, and that it basically prevents evictions based on non-payment of rent cases. And so what happens is that the CDC order, the tenant will just have to say, look, I can't pay my rent due to COVID, and I will sign a declaration saying so, and they give that to the landlord when they get they're about to be evicted, or at least when they can't start paying the rent, and say, look, this is, I declare all of this stuff, you can't evict me right now. So there are a long list of things that the tenant has to declare as part of this declaration statement. So a lot different than what the Minnesota moratorium is, where tenants just automatically have the protections. This one, it's more of a tenant has to actually proactively utilize this protection in order to get it. There's some resources here if you want to dig more into this. Maybe you're also doing stuff in other states that don't have as much protections as Minnesota does. So the actual order itself, National Housing Law Project has some good deep dives into this information, as well as the National Low Income Housing Coalition. There are a couple of things though that should be considered. Like I said before, this doesn't really apply in Minnesota just because our current moratorium is much more protective than the CDC order. But it could be argued that the family exception that I talked about earlier is actually less protective than the CDC order. And so it could, if you had a case that was bringing up that exception, you could try and argue that the CDC suspension also applies to that particular case. There hasn't been any court cases that have actually gotten to a hearing stage trying to use that argument. The ones that I'm aware of well settled before then, but it's definitely an argument that you could try and make it for one of those eviction exceptions. And then I'm going to turn it back over to Larry.
Thanks. So I want to talk just very briefly about mortgage foreclosures. The executive order does not stop the mortgage foreclosure process, but it, as we discussed earlier, would affect whether the bank could proceed with an eviction case. And again, because paragraph 5 does not allow law enforcement to enforce a writ unless a case meets the exceptions that Rachel just discussed, and that would apply to both commercial and tenancies and mortgage foreclosures as well. For a mortgage foreclosure eviction to be successful, it's going to have to meet those exceptions. Now, with that being said, there have been some moratorium of some mortgage foreclosure processes that are essentially connected to federal agencies like HUD and the Federal Housing Agency and Department of Veterans Affairs, the Department of Agriculture. So at this point, those foreclosures are suspended through the end of June. So that also is kind of lining up with the CDC order on evictions. The judiciary has been involved with, as you probably all know, issuing orders related to the pandemic. They have morphed a lot over time. You probably know what all the kind of restrictions are right now, but basically we're in a relatively remote universe in terms of doing court cases, but the court does have to maintain some in-person availability when needed. And some of that's discussed here. If you haven't been to the court's emergency website at the bottom of the page, you should do that and look in your specific district to see what special orders you have in place there. The legislature, both last summer and in this session as well, has relaxed court deadlines created by statutes. And that relaxation goes until April 15, unless it's extended further. Where that is relevant to what we're discussing today is it gives the court the ability to push things out further. Where we're seeing that happen most often is in the scheduling of eviction cases. The court under 504B 321 is supposed to schedule an eviction hearing within 7 to 14 days. Under this executive order, under this session law, the courts have the ability to extend that out. And so there also are advocacy points here where you could argue for a longer stay of a writ than 7 days, or a longer period for continuance to schedule a trial based on this session law. I want to talk briefly about the impact of eviction suspensions on health. There's become a little bit of a statistical and a modeling nerd over the last 6 months, which may sound really dry. I actually am kind of geeky, so I found it kind of interesting. But the news is dark. So the modeling period for a lot of these studies was until September 4, because September 4 is when the CDC eviction suspension went into place. And so up until that point, only states like Minnesota that had our own state eviction suspensions, evictions were flowing in other parts of the country. A lot of states held them up a little bit, but some let them go way earlier than others. What this one study estimated is around almost 11,000 deaths were caused in states that did not stop their evictions, with Texas topping the list. Also, there are also estimates of how many lives were saved in states that did not open up their evictions. And in the summer period, the estimate was around 700 lives in Minnesota were saved. And so why this discussion of deaths and lives saved related to eviction suspensions? Well, you know, it's actually a fairly easy explanation. If you evict this household, it's going to line up with some other household somewhere. And it might be in a tent, it might be in a shelter, it might be on a curb, or it might be in doubled up housing. And so by essentially intersecting these bubbles of households is what increased infections. So the infection rate in Minnesota was relatively low in the summer. So when you look at the number of lives saved in Minnesota versus other states that had eviction moratorium but had higher infections, more lives were saved there. But as you all know, it got much darker in the fall. Our infection rates and our death rates went up exponentially. And so as I poured through these studies and reviewed them and compared them with the data in Minnesota in terms of infections and deaths, my estimate is that our eviction suspension through January 4 saved around 2,000 lives and about 100,000 infection cases. So this is important stuff, not just for the tenants involved, but for the public in general. So now we want to talk a little bit about how evictions work. For those of you that are new to it, for those of you that have been around it, don't worry, we're not going to spend a ton of time on this, but this might be a good refresher for those of you that maybe haven't done an eviction for a while because we have less going through the pipeline right now. So they're governed by Minnesota Statute 504B, but also the common law of contracts and property. Appearances outside of Hennepin and Ramsey County, attorneys have to represent corporations and LLCs. Unincorporated businesses and individuals can appear pro se, and a management agent can represent an unincorporated business or an individual owner. The area of law is a little bit confused in Hennepin and Ramsey County because of a Court of Appeals decision that, in my view, was decided wrongly, but we'll see how that shakes out down the road. But for those of you that practice outside Hennepin and Ramsey County, corporations and LLCs must be represented by counsel. Tenants and landlords can be represented by a non-attorney if that person is not collecting a fee for the services that they do. Effective March 1, eligible legal paraprofessionals or paralegals can participate in a pilot program that allows them to represent in eviction cases and expungement cases. That's just opening up right now. I'm not aware of anybody who has started doing that work or if there's been any training on it yet. But if you have paralegals in your firm and they're interested in doing some pro bono work, this would be a way for them to get involved. So eviction basics, some of this ought to be, kind of no big news, but a lot of landlords think that they can just kind of believe something and that's good enough, or they can just put in the complaint and that's good enough for evidence. Plaintiff's got to prove the claim with preponderance of the evidence, and the court's supposed to make specific findings. All the rules of court apply, rules of evidence, civil procedure, general rules of practice. The housing court rules of the general rules of practice only apply in Hennepin and Ramsey County, but the rest of the general rules of practice apply statewide. Hearsay statements follow the same rules as in any other court proceeding, and that parties and lay witnesses can testify about what they observe without being an expert. The statute requires fact pleading in eviction cases rather than notice pleading that we have for other types of civil litigation. So that there needs to be some specificity there. And also landlords have to disclose information about how they can be contacted. And there are eviction action complaint forms and instructions on the court's website. Service is, it's a very kind of persnippety area. You need to be precise if you're on the landlord side in following the service statute. And on the tenant side, you need to be analytical about whether the plaintiff has been precise. So the three main categories of service are personal service, that's the least regulated, simply has to be done 7 days before the first hearing. Two types of substitute service are more regulated. The least regulated one is substitute service on a person other than the defendant that you are intending to serve. That person who receives the court papers for the person you're intending to serve has to be of suitable age and discretion. They have to reside in the unit, and they have to receive the court papers in the unit. For mail and post, that's the most regulated type of service. And there are a couple of district court decisions saying that the statute is sequential and landlords have to follow the sequence of the statute, which would mean being unsuccessful in personal service at least a couple of times on 2 different days, at least once in the evening, then mailing a copy of the summons to the defendant, and then going back to the property a 3rd time and posting, and then filing an affidavit of posting. So essentially 3 visits to the property and 3, in the old days, visits to the court, or 3 kind of interactions with the court over that process. Some landlords have been doing expedited evictions. If you're a landlord attorney, I wouldn't recommend it because there's a little bit of a minefield there. I think why some landlords have been doing that is that there's a reference to expedited eviction cases in the executive order. They don't go that much faster than a regular eviction case. And the real minefield is that service has to be complete within 24 hours of issuance of the summons. And as you can just see, if you have to do mail and post service, it's certainly possible to complete that whole sequence of events in 24 hours, but it's not easy. And so if you see an expedited eviction case on the defense side, you also want to look at the time frame in which service was completed. Not only was it done proper in terms of the things we just discussed, but also was it start to finish done in 24 hours. The courts have said that strict compliance is the standard for service, so that's why we look at it so closely and so technically, that close enough is not good enough. And lastly, service by the plaintiff is improper, and a number of court decisions that have said that that extends to kind of the brain trust of the plaintiff as well. So anyone who is not wholly disinterested from the outcome of the case, someone who's not wholly disinterested should not be doing the service. So as I mentioned before, scheduling under 321 is between 7 and 14 days. It's scheduled a little bit quicker for an expedited case, but the courts have the ability to relax that under the session law that I mentioned. There have been some court administrative orders, mostly in the 2nd and 4th district, about how evictions are different now. As you can see, some of them are talking about that evictions will remain confidential when they're filed until it's determined if the landlord is able to proceed with it. In other words, the landlord files a case that doesn't meet the exceptions. Courts can say, we're going to treat that as confidential, figure out if it meets the exception. If it doesn't, we're going to dismiss the case and the case never becomes public. If the case proceeds, then it does become public. Other things courts have been looking at is requiring landlords to say whether or not they're covered by the CARES Act, and if so, that they've given the 30-day notice and that they've given the 7-day notice of intention to file the case before they file it. So let's talk about some of these, how the courts have been dealing with the executive order here. So again, we have two different types of notices. We have pre-filing termination notices, and we have the notice of intent to file the case. Now, not all properties require a pre-filing termination notice. And so this is the list of where it is required. If the landlord is using the landlord family residency exception, the landlord's got to give that notice that that Rachel mentioned earlier. In a month-to-month tenancy, that should be a 1-month notice. With a lease with notice provisions, it should conform to those notices, but it also should wait till the end of the lease. So let's say you've got a 1-year lease and you've got 2 months left on it, and the landlord wants to rent to a family member now. Since the executive order didn't create a new ground for eviction, if the tenant has been lease compliant, then the landlord has to wait for expiration of the lease and then not renew the lease and use the family exception as the basis for not renewing the lease. But then part of that would be the expectation that the family member would move in within 7 days. If it's a month-to-month tenancy, the landlord would give, the month-to-month tenancy doesn't have a termination date or an expiration date. So the way you determine that expiration date is by giving a 1-month notice. And so that's the type of notice that would need to be given here. So for CARES Act covered properties, those federally subsidized and federally backed mortgage properties, it would be a 30-day termination notice. For manufactured home parks, they have various notice requirements, and there are also notice requirements in post-mortgage foreclosure and contract for deed cases. Now, for all these, with the exception of the family residency exception, if we're looking at a CARES Act property or a manufactured home park or a mortgage foreclosure contract for deed cancellation, besides giving the notice, the case would still have to fit the exceptions of the executive order. So for instance, a CARES Act property can't say, I want to give a 30-day notice for non-payment of rent. The CARES Act says you got to give 30-day notice, but the executive order says what are the appropriate grounds, and so non-payment of rent would not be an appropriate ground. So then the second notice is the notice of intention to file, okay? And this is the way the executive order is written. I think this is actually not for all eviction cases. It's all eviction cases against tenants, because tenants are discussed in that section of the executive order. So I think if you're doing a mortgage foreclosure eviction case or a commercial eviction case, it does not involve a tenant, or doesn't involve a residential tenant, wouldn't have to give that notice. But that's such a small subset of what we're seeing right now. What we're seeing right now in terms of cases that are proceeding are cases against tenant. And again, as Rachel was saying, this is where landlords are more often than not getting it wrong, and the courts are seeing that and dismissing those cases. And this is just a small list. There's a greater list of these cases in the manual that I discussed earlier. So because we've got a couple different notices here, I mean, every eviction case against a tenant is going to have this notice of intention. Okay. And then some other eviction cases are going to have another notice as well. Okay. So we need to remember that there are defenses related to notices that have nothing to do with the pandemic. So one would be, is the landlord retaliating? So does the landlord have this cause for eviction? Like maybe they're alleging, substantial endangerment, or they're alleging family member exception. And the tenant believes that's actually a ruse for the landlord retaliating against the tenant for asking for repairs. The tenant can raise that defense. Landlords can waive notices by accepting of rent after the move out date. And there's a greater discussion of notice defenses, both in my residential eviction defense manual and in my answer forms. Okay, so another area of exceptions are the 504B.171 claims. And while, as Rachel said, there's a larger category of subjects that can fit into that, traditionally, most 171 cases have involved illegal drugs or firearms. And that's essentially what we're seeing in the pandemic as well. It's interesting, Rachel was mentioning that we sometimes hear people saying, well, I've got this nasty person and I can't evict them. And I think they're just not reading what the law is, because if someone's engaged in drug activity, they've got firearms, they're engaged in harassment or domestic violence or something like that, 504B.171 gives the ability to evict for that, and the executive order has that as an exception. But when it's my mind good here is that the courts are really looking at these cases and figuring out, sure, you believe this landlord, can you prove it? And so we see cases where the analysis is, well, there's a smell of marijuana. Can you pin it to this apartment? Or that there was a gun on the property. Can you pin that to the tenant? And if you can't show that kind of causal connection, it's simply a belief, then you're going to lose, the landlord's going to lose that case. Now, certain defenses that are also available in 171 cases is if it's involving illegal drugs in the property, that the tenant didn't know or have reason to know that the drugs were on the property, or the tenants couldn't prevent them from being on the property. And also medical marijuana is legal in Minnesota, so that would not be illegal drug use. For significant property damage claims, I think we've probably seen more of those in the decisions I've seen coming down than in the other categories. And sometimes the landlord's able to prove it, sometimes they can't. Here are a couple examples where the landlord was able to show that there was significant property damage, and the court evicted. On the other hand, we've had a number of cases where the courts have looked carefully to see if the damage really, maybe there was some damage, but was the damage significant? Was it minor or was it significant? And in that context, the courts have been mindful of the fact that we're in a pandemic. And so maybe if there had been some damage that a judge or referee might have evicted for before, maybe they won't in the pandemic because of the health aspects of it. Substantial endangerment claims. The reason I cite this Court of Appeals decision is it talks a little bit about pleading specificity that I mentioned earlier. So this was a case where the landlord was saying substantial endangerment, but did not go into much detail. The district court decided to not proceed with the case, and the landlord essentially went to the Court of Appeals and said, Court of Appeals, order the district court to proceed with the case. And the Court of Appeals affirmed essentially, or essentially denied the motion denied the petition and essentially affirmed what the district court did and said you hadn't pled with enough specificity, the court had done the right thing. And so we certainly have some cases where the court has found that some substantial endangerment occurred, and we have others that have said it hasn't risen to that level. In the family residency claim area, the decisions are telling us a couple of things. One, that the courts are really looking at the word need. Does the landlord need this specific property to move in this specific family member? And in the Borsay case, the court said, no, you've got a number of properties. You haven't convinced me that this was the only place where you could move in your daughter to have space on the property. Also, we've got the Rogenkamp case down here at the bottom saying, in my mind, there's a little bit of a no-brainer that an LLC can't have a family member, so they can't avail themselves of this. So this is if you have a family member exception case, this may sound like kind of a no-brainer, but look at the name of the plaintiff. There are a lot of landlords that organize themselves as LLCs these days, and there's nothing wrong with that. But they do that for tax reasons, they do it for personal liability reasons. But availing themselves of that essentially precludes them from using the family residency exception, even if it's a solely owned LLC. Now, part of what Rachel and I have been discussing with judges around the state is that you have equitable power. And a lot of times judges think that, well, they don't really have equitable power, there's a statutory proceeding. But the case law says they do. The Naftalin and the Warren cases say that even where a tenant has breached the lease in a material way, the court can allow the tenant to stay if the landlord's adequately protected from further breaches. And so we have a couple of decisions here where the court used that kind of power. We have in the Kelly case, the court ruled for the landlord but gave the tenant a month to move rather than 7 days to move. And in the Henry case, the court found that there might have been some significant property damage, but the tenant had essentially cured that by the time the case went to court. But the court also went on to say, we're in a pandemic here. I need to be cautious in where I evict and where I don't evict. So because these types of exceptions, 171, significant property damage, substantial endangerment, are essentially breach of lease cases, don't forget about all the other issues that you have to analyze in a breach of lease case. Is the breach material? Does the lease have a right of reentry clause? Has the landlord waived breaches by accepting rent or even waived the lease provisions themselves? Does the tenant have a disability that the landlord didn't reasonably accommodate? Is the landlord penalizing the tenant for calling the police? Is the tenant a victim of domestic violence? Is the landlord retaliating? So, in any kind of area of law, it's easy to kind of get a little too far into the weeds and forget about the larger kind of universe. So don't forget about everything you already know about eviction defense just because we're analyzing cases under the executive order. And I have a section on breach of lease defenses in my manual and also in my answer forms. So now I'll talk a little bit about relief. Obviously, if you're representing a defendant, you would like that case dismissed or judgment entered for the defendant. If you have an improperly filed expedited eviction case, ask for a $500 fine. In the manual I just published today, there is a case where the court found that the landlord filed an expedited case when they didn't have a basis for doing that and fined the landlord for that. If the tenant loses, ask for time to move, but I think you can ask beyond the 7 days because of the session law and also because of the court's equitable powers. You can ask for costs and disbursements. You can ask for expungement under statutory expungement or common law expungement. You can ask for attorney's fees if there's attorney's fee provision in the lease that benefits the landlord. Now we're going to talk a little bit about planning for after Executive Order 2079. Evictions before the pandemic, you can see some of the numbers here, around 16,000 statewide, and we've broken it down a little bit for our counties and districts. Okay, we're about 1 year out of the eviction suspension. And so one could say there's that many evictions on hold, maybe a little bit less because maybe people have negotiated and some evictions have gone through the pipeline. But keep in mind, before, these are numbers not in a pandemic and not in a recession. And so we need to look at the economy to see how that might impact the numbers. Unemployment's high. It's certainly not as high as the high point last May, but it's still up from where it was a year ago. And when you look at cumulative unemployment applications during the pandemic, and compare that with the workforce size before the pandemic, you can see we have a high percentage of people having applied for unemployment sometime in the last year. That doesn't mean they've been employed the whole time, but at least they were unemployed part of that time, and that may have an impact on their ability to pay the rent. The numbers are pretty dark here, from around a third of the workforce to 2/3 of the workforce up in Roselle, Minnesota. And the census has been compiling data on a lot of different demographics, including tenants. And these are the estimates as of March 10th of the numbers of tenants. They didn't survey everybody, they surveyed a sample and they extrapolated out. So what they extrapolated out is over 100,000 behind on the rent, over 200,000 unemployed, almost 400,000 having a loss of income, and this is of tenant households, over 100,000 thinking they don't have much confidence in paying the next month's rent. And when you look, and then almost 70,000 thinking it's likely they're going to get evicted in the next couple of months. Take any of these numbers, smallest or largest, and compare it to 16,000 statewide, and that's massive. And so there's certainly a high likelihood that any county in Minnesota, once evictions are opened up, could have a year's worth of evictions immediately or maybe more. And my analysis is in line with what some of the national estimates are of potential evictions in Minnesota, being anywhere from 32,000 to 280,000 when they open up. Okay. There's some planning going underway, both and a number of courts are talking about it. Some have actually issued orders in the 4th and the 2nd and the 10th district for Anoka that involve some staggering of evictions when they open up. And you can look at these links to see what they're having to say about it. There's also talk in the legislature. There are 2 bills, one in the Senate, one in the House. The Senate one would open up evictions upon enactment because it would void the executive order, and then it would stagger them out. The House one would open up evictions a little bit on enactment, but for the most part would hold up evictions until the peacetime emergency ends. I think the House bill is better than the Senate bill, but we'll see what happens with them. It is time to plan. The legislature should be having those conversations, but in addition to that, looking at financial assistance to landlords and tenants and to legal aid programs and mediation programs and judicial resources for evictions. And, I'm glad you're attending this training because we're going to need more attorneys for tenants and more mediators for tenants. And hopefully the courts around the state will look at both staggering evictions and applying more judicial resources. So now I'm just going to talk briefly about what happens when non-payment of rent start up whenever they happen, okay? Again, landlords have to prove what is owed. Some cases will require a pre-filing notice, termination notice. Manufactured home parks, covered properties under the CARES Act, and even if the CARES Act ends at some point, most public and subsidized housing properties have notice requirements for non-payment of rent cases. The most common defense in non-payment of rent is habitability, especially for people with low incomes. We could spend a whole hour talking about that, so we're not going to do that, but we've got very good laws on it. The thing to really put your attention on is a number of courts over the years have said that tenants have to pay past rent into court in order to litigate. And that really is not what the law says. When you look at what the court said in Fritz versus Warthen, it all talked about future rent to be withheld, not past rent. And whenever eviction cases open up, we may have tenants with fairly large debts, and whether they're able to litigate habitability is going to be based on whether the court follows Fritz and says you only have to pay rent into court as it comes due, or if the courts basically disobey Fritz and say you got to pay past rent. Other non-payment of rent defenses include non-compliance with local licensing ordinances, violating landlord utility laws, violating late fees restrictions, waiving rent claims by accepting partial payments of rent, and retaliation. Now, I want to talk a moment about redemption, because this is another area where I think the courts often get this wrong. I often hear from judges and referees that, okay, I can give the tenant 7 days to pay rent, but that's the most I can do. And that's just an inaccurate statement. There is no limit by statute or case law on the amount of time the court can give a tenant to pay rent due, or the conditions that the court can consider. And there's not a lot of law out there. There's a court decision from back in 1972 that was affirmed in 1973, where the court gave a commercial tenant 1 month to pay the amount in default, and the Supreme Court affirmed that. And so I think whether you're basing it on the 614 case or the court's equitable power, when cases open up, this would be the time for us to really advocate strongly for a broader interpretation of redemption. There's nothing that precludes the court from saying, I'm going to let the tenant do a payment plan, landlord and tenant, you go figure it out. Or I'm going to give the tenant time to apply for financial assistance, and we're going to wait and see if that happens. And so I think we're really going to have to push against this misperception on the limitation of redemption rights. And if you need to know more about non-payment of rent defenses, I've got it on both my eviction manual and the answer forms. Now I want to talk about one other thing that's not an eviction issue, but I think we're going to see a lot of it. I've gotten a lot of questions about this already. I want to walk away from my lease because I can't afford it. And the executive order did not release tenants from rent liability, and none of the things that we've discussed so far have done that. So when can a tenant get out of the lease or eliminate that rent liability? Well, we're not encouraging tenants to die, but death of the tenant can end the lease. A tenant who's a victim of domestic violence can end the lease. If you have constructive eviction because of the housing becoming uninhabitable or unfit for occupancy, you can get out of the lease. And all these getting out of the lease means ending the rent liability as well. And if you have privacy violations, one of the things the court can do is let you out of the lease. One area that I've been researching the last few months, and I've got a section of it in the new Pandemic Eviction Defense Manual, is analyzing the doctrines of frustration of purpose and impossibility or impracticability of performance. There's actually, a decent amount of case law in Minnesota on this subject. There are 2 court decisions in the pandemic, one that I found, one in Minnesota and one that I found in Massachusetts. The Massachusetts one, they both involved restaurants. And in the Massachusetts one, the restaurant lease started a few years ago and was going to go for 15 years. The restaurant wasn't able to operate in the early parts of the pandemic. And the court said that I'm essentially releasing you from financial liability for that period in which you weren't able to operate. Okay? The Minnesota decision ruled for the landlord, but there the tenant had renewed the lease during the pandemic. And so I think part of what the court focused, and plus there was a provision in the lease that essentially dealt with impossibility and practicability. So there the court said, we're not going to let you out of it. But I think it was telling that the tenant had re-upped the lease after the peacetime emergency, while in the Massachusetts case, the lease, there hadn't been any re-upping in that time frame. So I think these are doctrines that we ought to be looking at when we have landlords suing tenants for substantial debt, and so the last thing is that, I've had conversations with landlords and tenants, and I've encouraged them to let the tenant out of the lease, because in my view, it's not a foregone conclusion the landlord's going to be able to collect that based on some of these principles here, and that the landlord actually maybe has a better shot of actually getting some money in by trying to rent to someone who can actually afford it. So last few things here. I've got contact information for the mediation programs, got for the legal aid offices around the state, including Volunteer Lawyers Network. Volunteer and donate to them. You can also volunteer and donate with other organizations that provide advice, assist law students with tenant organizing. You can also volunteer and donate with advocacy groups, including Homeline and Volunteer Lawyers Networks and the other ones that are listed here. And you can also advocate yourself if you've got strong feelings about whether these, whether protections ought to continue. There's activity on all levels of government, and feel free to reach out to them and tell them what you think. So with that, we got a little bit more time for questions. I see there's a little bit in the Q of A. I don't know if I've missed anything or not. I'm gonna stop the share here.
Yeah, it looks like there's a couple Q&As and there's a couple in the chat as well.
Okay, so I'll just start with a Q&A and take a look. What if the landlord's attorney does service? Is the attorney part of the landlord brain trust? Attorneys can do service. We are officers of the court. And so we can always serve both in landlord tenant cases and in any other types of cases as well. Another question, any hope of moving towards having all eviction cases confidential from the start until the landlord prevails? There's actually a legislation on that before the legislature. We'll see how far that progresses. But there's a number of eviction reform bills from Homeline, from Legal Services, and from my organization, the Lawyers Committee for Civil Rights Under Law, and that's one of the elements. So we'll see what happens with that one.
Yeah, there's a lot of stuff going through the legislature right now that's beyond just the off-ramping bills that Larry talked about.
Yep. Okay, another question. For a month-to-month lease where the leasing month ends at the end of the month, would 30 days be sufficient if that ends in the middle of the month, e.g. notice to vacate April 15 given on March 5, even though it's a month-to-month lease that ends on April 30? So short answer is no. The notice, first of all, it has to be a 1 month notice, not a 30-day notice. And it has to line up with the rental period. So if the rent is paid, if the lease, if this relationship began on, for instance, April 15th, so it runs from the 15th to the 14th, then the notice would have to be given before the 15th of the month to be effective basically halfway through the end of the next month. So, and that's based on case law that we've had for a long time. So when you have a 1 month notice, unless a lease says something different, it has to track on the kind of the cycle of paying rent. Okay, so I'm gonna take a look at the chat right now. Oh man, we got a really long one there.
Yeah, it looks like there's one that just wanted to point out a dead link in your page.
Okay. Okay, so let's see, what's the really long one here? I'll start at the bottom actually.
Okay.
So, so one chat is some large property management companies. The owner does volunteer work as a mediator, resolving landlord tenant disputes. I'm not sure what that's getting at, but okay, I'll get to the one above that. Have you read these? Do you want to try answering any of them? I haven't read them yet.
I read through the long one while you were looking at the other one, and it's about a volunteer who actually represented a landlord in a eviction action. And basically, the judge had set the trial that the tenant asked for the next day, and the tenant was showing pictures of the landlord's belongings, claiming the landlord was allowing like drugs on the premises, and that so as a defense. And the judge just dismissed it, saying that the landlord should be filing a harassment petition and not an eviction action, and wasn't certain why that happened. And I mean, so it is supposed to be, and they go on to say, housing court is supposed to be settling landlord-tenant disputes. And the thing is that the landlord, it would be good to know why the landlord was filing the eviction in this case, like what reason they had, if it was during the pandemic or not, because ultimately what it is that the landlord is looking for possession of the property. That's what an eviction action is really for. And so if the tenant's defense of, that the landlord was allowing drugs on the property really is not a, it's a defense in that like both the landlord and tenant agree not to allow illegal activity on the property, but really the landlord is the one who's trying to evict. And I didn't see in your response why the landlord was, what the reason was the landlord was evicting.
Yeah, I mean, sometimes it's hard to analyze why a judge does this or judge does that unless they have it written in specificity in their order. That's one of the reasons why they're supposed to have something specific in their order. It could be that the judge just came to the conclusion that both the landlord and the tenant are crabby with each other, but couldn't really figure out if there was something that actually specifically met the exceptions, and so therefore said, I'm not going to do anything with it, but maybe wanted to throw the landlord a bone and say, well, if you want to try to do this somewhere else, you can. Because, if the landlord could be successful in a harassment petition against a tenant, in theory, they could be successful in the eviction case as well, because 504B.171 cross-references in a harassment case. So it seems like if you could win it in one place, you'd be able to win it in the other place. So I think what was probably going on there is the judge just wasn't really happy with the presentation, just wasn't happy with as he or she saw the merits of the case and decided to punt it. Okay, see anything else, Rachel, in which
Looks
we
like
need to respond?
got a couple more questions in the Q&A. So I'll just read this one. I'm reading it cold, so I have no idea what it is. If a tenant is months behind on rent and receives a lump sum payment, such as a stimulus check that covers some rent, but not all past due rent, are you advising the tenant to pay the lump sum to the landlord? What factors do you consider when advising the tenant? So just my 2 cents in on that is it really depends on what the tenant situation is. If they need that money to pay other bills as well, the eviction moratorium right now does protect them from being evicted for that reason. The landlord's not supposed to kick them out for not paying the rent. So a lot of it's going to probably be dependent on what the tenant's situation is outside of that. Now, if they're getting, say, the emergency rental assistance funding, obviously that needs to go directly to the rent, and that should be the lump sum to cover whatever is past due. And the new program is actually also going to be forwarding for forward rent for the next 3 months as well. So that's an option. But if it's just getting their $1,400 stimulus check, if there's other things like groceries that the tenant needs to pay for, depending on how much of a drop in the bucket it's going to be for their rent. At this point, they're protected under the moratorium, so it might be better used other places.
Yeah, but the other thing is that the tenant, because of the moratorium, has decent bargaining power. And so if the tenant's getting a decent lump sum check, perhaps having a negotiation where the tenant either pays part of that or some of that to the landlord, and maybe the landlord comes down on the rent debt, or maybe they reach an agreement that when evictions open up, that there's still going to be some time period for the tenant. Because, we don't know when evictions going to open up. But let's say, for instance, they open up in the end of June, okay? And the tenant's got a lump sum, and that's going to cover everything, but they're still, given, and maybe they're able to pay rent now, but they're still going to end up with a couple thousand they can't pay. The landlord may have some incentive to get that money to work out an agreement with the tenant where, whenever evictions open up, we're going to have a 2-month period or whatever to try to bring everything in, try to bring us together. And maybe the landlord comes down in the amount in the time, in the moment.
Yeah.
I mean, tenants really have a lot of bargaining power that they haven't had in the past because of this moratorium. And that's flowed into a lot of areas, not just in negotiations over rent, but, say the landlord wants to come and do repair work and the tenant says, well, no, I'm not going to let you do that unless you follow hygiene stuff. And the landlord says, well, I'm not going to do that. And tenant says, well, you're not coming in. Well, in the past, the landlord maybe would be able to evict the tenant for not letting the landlord come back in if that was a provision in the lease. But now that's, if it doesn't meet an exception, the landlord can't do that. So now the tenant's got a little more bargaining power to say, this is how I think we ought to do this. You ought to come in when I'm not there, and then you need to do these types of hygiene procedures when you get done. Tenants have more bargaining power now.
Absolutely. Next question on the QA is, if a landlord has electronic payment systems in place and will receive payments automatically, can the tenant claim that any electronic payment constitutes acceptance of rent and is deemed as consent to extend the lease? I mean, if rent is due, say, on the first of the month for that month, if the landlord takes the rent, then that is an indication that they are giving possession of that space for at least the next month.
Yeah, I agree with that. It's simply a different method of payment, but it's still payment. And what the case law tells us is that if a landlord accepts rent after the effective date of a notice to move out, that's a waiver. Sometimes a non-waiver clause can work against that outcome. But without a non-waiver clause, in my mind, that's kind of a no-brainer. It was the landlord's choice to set up something automatic. And the acceptance of rent can be waivers of alleged violations of the lease as well. So let's say you have a significant property damage case, but the landlord's accepted rent for a couple months after that, and they don't have a non-waiver clause in the lease, even though they might have that substantial damage or significant damage or endangerment or something. The principle of waiver might actually mean that the landlord doesn't have the remedy of eviction.
Right, so we're at 1:26. I think we still have quite a few minutes to be able to do this. So the next question, so is there any concern that if a tenant reveals the fact that they may have some money to pay rent right now as part of their negotiations, could that fact be used against them in any ultimate eviction action? That's a good question.
Yeah, I don't see what that would be.
I think the bigger concern at this point would be that the landlord still has the right to sue for the money owed in conciliation court, or however, if it's larger in regular district court. But and then if they have money, that can be something that can be problematic. But as far as the eviction action, with the moratoriums in place, it's very clear that they can't be evicted for non-payment of rent.
Yeah, and even when evictions open up on the issue of rent, it's either the tenant's going to have the rent that the court says is due or not. So I don't see a big downside to having a negotiation now that might lead to a reduction of the overall debt.
Okay, and Virginia is asking, what is your projection about lifting the moratorium when it looks like the fourth wave is upon us?
Well, right now we've got, on the federal level, we've got moratorium kind of extending out to the end of June. I would be surprised if the governor moves faster than how things are going nationally. And with the division in the legislature, the Senate bill that would void the executive order, whether it passes the Senate, it's not going to pass the House, and if it did, the governor would veto it. So I don't see the legislature taking the governor out of the mix right now, and I don't see the governor. I can maybe see the governor opening up evictions a little bit, like maybe expanding them out to other types of non-rent breaches of the lease. So my best guess is that we're looking till the end of June at the earliest.
And something else I think is important as well is that both the houses, the Senate and the House, agree that some sort of off-ramp is necessary. They really feel that they know that the courts can be overwhelmed by the potential eviction actions, and it would just be absolute chaos if all of a sudden thousands upon thousands of eviction actions were filed and thousands of people were suddenly homeless. Like both everyone has acknowledged that some sort of off-ramp is probably necessary. And so they're just arguing about what that looks like now. So I think it's also fairly safe to assume that while they're still negotiating that, there will be some sort of stop in place until we know what the off-ramp looks like. Okay. So it's 1:30 and Mariah just kindly reminded me that we were going to 1:45. So
we'll jump in here and first of all say thank you so much for your time. So tremendously informative and in-depth, and you covered a lot of information in a short period of time. So thank you so very much. Since we have a few minutes, I do want to jump in and just tell you a little bit about what VLN sees for its attorneys and our volunteer attorneys in the future and coming towards the end of the moratorium. What I would like to do is just, what we need to do is we need to keep in communication with you as we see things develop. And we just don't know what the end of the moratorium is going to look like. I'm hoping it's not a cliff and that the doors open quickly and all sorts of cases pour through at once. I'm hoping for something more that I analogize to a tail or the off-ramp people use, that cases just slowly start to come forward. And it looks like that those cases might start to come forward as breach of lease cases. But all of this really is still in the creation. So we don't know what it's going to look like. But as soon as we do know what it's going to look like and what our volunteer needs are, we're going to be reaching out to all of you and asking you to sign up to come help advise tenants. And we even advise some income qualified landlords about their rights at the end of the moratorium. What I'm going to do is I'm going to share my screen with you to show you Volunteer Lawyers Network's website and where you can find the Housing Volunteer Resource page. And this is where we're going to be putting most of our information coming forward. Also going down, if you're not yet on our mailing list, you can register here to get our mailing list. We send out a monthly newsletter, which gives updates. And we also do, if we have cases right now that we're looking to place, and we'll be informing people about what will be happening at the end of the moratorium also. However, don't feel you need to wait till the end of the moratorium. We really do have some great volunteer opportunities for people right now. If you are brand new to housing law and want to get involved, I would encourage you to do eviction expungement. We've been doing a lot of eviction expungements here in the moratorium. Makes a big difference for a tenant to get that eviction off their record. And it's something that I think is a great volunteer activity to do. Not time sensitive. There are much less hearings than there were historically. So it may be just really a drafting and filing of paperwork. And if you talk to us and we know what your skill level is, we can match a case that is equal to your skill level. And then we're here to support you. We have our resources online. We have 3 staff attorneys at VLN who are really here, and our job is to support you in your work. Another thing we do is we have phone advice clinics. Phone advice clinics take place every day from 2 to 4 p.m. It's another great way for volunteers to start in housing law. You get all of the case information in advance, including the number to call, you know what the issue is. And if you want, VLN attorneys can talk with you about the situation before you call the client, kind of give you a strategy of the advice that you're going to give the tenant or the client in that phone advice session. And then if something comes up during that phone advice session that you weren't expecting, you can just say you need to consult a colleague for a moment and call that person back. So it really is, once again, a great way to start getting involved in housing law, even before the moratorium ends. And finally, we are currently at the housing courts in Anoka, Ramsey, and Hennepin County at the initial appearance eviction calendars right now. If you like negotiations, if you like appearing in court, if that is your thing, I have to say, for those that like it, it's an invigorating experience. Let's just say it that way. And you're making a big difference in people's lives. And as Larry and Rachel have said, right now, tenants have a lot more bargaining power than they used to. And it's a lot trickier for landlords right now to appropriately file evictions. So we have shadowing opportunities if you'd like to see it first. We have VLN support staff that are on those calendars with you. So we really have a lot of opportunities for you right now that are carefully planned for volunteers, if that's something that you're interested in. If you have questions, you're welcome to email me or any of my staff. Our contact information is on our webpage. But I would just like to extend one more huge thank you to Larry and Rachel for all that they did for us today and that they're doing throughout Minnesota here in this period of the moratorium and afterwards, and helping for preparing. So thank you everyone for your time. I hope to see you all on some phone advice shift or on an eviction expungement case or after the moratorium. Take care and enjoy your beautiful Friday afternoon.
So
All right, I think that went well.
yeah, I think that was great. So thank you very much. I'm going to take off now.
Okay, we'll see you guys
Thank you
later.
very much, both of you, Larry and
All right.
Rachel.
Bye.